The participants on this panel here will offer their reflections. For those who knew Justice Scalia personally, it was a gift. People here on this panel were his fellow students, his colleague, and some of them knew him as a boss. We will hear from them. His gifts as a communicator were as substantial as his personal charm. I hope to hear about that too. I give my thanks to all the participants and will be joining them as well. The panel will be moderated by Professor Frank Michelman, who was a fellow student with Justice Scalia.
Okay, thanks, Dean Minow, and thanks to everyone here who's come. The 8 of us up here, as Dean Minow said, are all people who have had some kind of direct personal or professional connection with Justice Scalia. Some were his law clerks. Some advocated, practiced law in his court. As Dean Minow said, I was his law school classmate. Professor Sunstein was his colleague for a while on the faculty at the University of Chicago. But I take it it's this common sharing we all have of a personal connection with Justice Scalia that accounts for our having been convened by the dean to this panel. In no other respect that I can see could we be called a representative group. Dean Minow as convener and I as moderator are going to bring up the rear in this lineup to get us going. By the way, folks, we have approximately 40 minutes, just a little over 40 minutes for 8 speakers, and if you do the math, it comes out even, and you know how long you have. I thought I would start with somebody who we might say has a little bit of Justice Scalia in him. He's something of an originalist, as Justice Scalia was, and he's something of an original, as Justice Scalia was, and I give you Larry Lessig.
Wow. Boy, thank you, Frank, and I'm honored to be on this panel and sad to have to be on this panel. None of us expected to be brought to this moment just like this so quickly. I was behind John at the service on Saturday, and the emotion of that place with 4,000 people was overwhelming. Now, it's puzzling to many of my friends why I am an admirer of Justice Scalia. Justice Scalia's politics, his personal preferences, his judgment in many cases are all things that I would say I disagree with. But I can't escape the fact that he profoundly affected how I thought, how I think about the law. And he did that not in his theories, not by what he said, but by what he did. I'm not convinced this was true through his whole career. I'm not making any claim beyond what I know personally, but the experience that was most meaningful to me was to sit as his law clerk and watch him struggle with what he knew his principles said he should do and what he wanted as a conservative to do. And that conflict is not a conflict every justice in the Supreme Court has to face, because most of the justices don't have a theory which they've placed in the public domain against which their decisions can be tested. Most of them just decide the cases as they see them. But Scalia, especially in the first chunk of his career, made it a strong point to constantly ask, what's the relationship between originalism, or my view of statutory interpretation, and the answer in this case, and Often we knew that was inconsistent with what he would want, voting as a legislator or voting as just a citizen. In every single case where we saw that conflict, Scalia did what his principle said he should do. And what was most moving about that was very quickly when you're a clerk, you realize they can do whatever they want. And the clerks can write an opinion to justify whatever they want. There's no restriction except the restriction you impose on yourself. And when people of great power demonstrate their willingness to restrict their power in the name of something, whether you agree with it or not, whether you agree with that principle or not, that's moving. And I hope that someday I can look back on my own work and feel like I had acted with that kind of integrity, but at least in those moments to watch that integrity was an incredibly important part of what it meant to me to become a lawyer.
Great. Okay, I think we'll make a shift now from the law clerk contingent to the barrister contingent and call on Richard Lazarus.
Thanks, Frank. Well, I well remember when I first became acquainted with Justice Scalia. It was October 6th, 1986. It was the first Monday of October, the first day of oral argument, the first case. I was in the courtroom that day to watch, and I was a new young attorney with the Solicitor General's office. I was partly there because we had a brand new Chief Justice sitting for the first time, William Rehnquist. We had a brand new Associate Justice sitting for the first time, Tina Scalia. I was also mostly there because I had an argument the next day, on October 7th, and I wanted to see my first argument, and I wanted to see what it was going to be like. The case I was watching was Hodel v. Irving. It was a regulatory takings case. And the first lawyer out of the block was from the Solicitor General's office, a colleague of mine named Ed Needler. And he was no stranger to Justice Scalia. He had been his law student at the University of Virginia, where Scalia had taught, and he had been a former colleague of Scalia's at the Office of Legal Counsel. And what I and my other friends from the Solicitor General's office saw that day, let's just say it raised our collective eyebrows as we watched. And it was a sign of oral arguments and opinions to come. Scalia jumped all over the government lawyer for not raising Article 3 standing as a defense to the takings claim, for not being aggressive enough against the other side. That was news to us. We were not an office known for a lack of aggression, especially when it came to advocacy on things like Article 3. From that first day, that first argument, Scalia made clear he was going to do more than sit back and vote. He wanted to tell lawyers how to argue the cases. He cared about analytical frameworks, not just the answers. And that first day, it was on the threshold importance of Article 3. But the tutorial continued throughout the year, and we watched as repeat advocates before the court. You can all guess what the primary topic of instruction was. It was text. Case after case, argument after argument, he pushed us all. He pushed the lawyers to argue text. He chastised us and others for sloppy analysis, for relegating text to anything other than the first thing one talked about. And he jumped all over anybody for vague references to legislative history to suggest what Congress intended. And as Solicitor General's office lawyers, we were players. And we were tempted sometimes to try different analytical frameworks for different cases, depending on which would help the most. He would call us to task for that, asking us, well, you're on the plain meeting team today. Someone else from your office was last week. What about today? And it worked. He did no less than transform legal analysis. Justice Scalia's transformative impact on the Supreme Court was not his vote. It was his voice. He changed the way lawyers argue cases. He changed our framework. And so, too, he changed the way the justices and all judges analyze cases. Arguments became better, more rigorous, more precise, and less sloppy. It was true both for written briefs and oral arguments. It was famously so for oral arguments. He ignited the court. He sat back and he waited his turn. He did that the first day, and then he pounced. We all dubbed him the Cheshire Cat on the bench, grinning and waiting to pounce. In 1980s, before he got on the court, you could argue a case and have no questions, 0 questions. That changed when Justice Scalia joined the court. The average day is about 40 questions a side, and you can get asked 120 questions in 30 minutes these days. It's one reason why we've seen a rise in the Supreme Court bar. It's a response to Justice Scalia's demands on legal analysis. The bar had literally been raised itself by Justice Scalia, and we needed a new, better bar. And that's what's happened. We now have far more experts, far more frequent people appearing over and over again. That's no happenstance. Clients of all sorts realized we had a new game and required better lawyers before the court. In my view, Scalia's impact on the quality of argument, on his rigor, on his precision, is a good thing and worthy of great praise. As it happens, I'm counsel of record right now for a party who has a case before the court. Like Hodel v. Irving, that was argued on October 6, 1986, Scalia's first day, it again is a regulatory takings case. It looks like mine is likely to be set for that first week of October. It may well be the first case, almost precisely 30 years to the date when I first saw him on the court. It would be strange to stand up before that bench and not have Scalia there. I cannot say I'll miss his vote in that case. I won't. Justice Scalia was environmental law's greatest skeptic. In cases I have done, he has been my most persistent nemesis. While I won't miss his vote, I will miss his voice. And I'm grateful for his enormous public service and contributions to a nation he clearly adored.
Thanks, Richard. Adrian Vermeulen.
Thanks so much, Frank, and I apologize for having to run out early. I have a class I have to get to, but I'll stay as long as I can. So I toy with the idea that every person has a ruling virtue, a kind of master virtue. Maybe people also have a ruling vice, but we won't talk about that today. So their ruling virtue underpins and organizes all their other good traits and makes them who they are. I want to make a suggestion about the justice's ruling virtue. I think it was courage. So many people have remarked on his brilliance, his joie de vivre, his loyalty. I think all those are true, but I think that courage underlies them all in some essential way. So let me explain. His brilliance is not just a function of IQ, but it stemmed from a kind of courage to follow a chain of reasoning wherever it might lead, and ignore those kind of socially induced constraints and self-censorship that so many times cause us to stop short in our reasoning. His joie de vivre is famous, is a man bubbling with good humor. I think that's in part a product of courage, too. Fear's great enemy is joy, and this is a man who was joyful because he was often unafraid. And his loyalty, it was the courage not to fall away, not to deny a person or deny one of his commitments, even when the whole world was clamoring for him to deny them. So I think courage underlay all his other virtues in some way, and then let me leverage his courage into one prediction and one normative idea. The prediction is about his intellectual legacy and the half-life of his reputation. I think that because of his courage, he will be rewarded with an unusually durable intellectual reputation. So Mark Tushnet said to me that he thinks Justice Scalia will be like Justice Frankfurter, whose very high reputation faded pretty quickly as soon as his clerks left the academy. That's possible, and I understand why Mark thinks that, but I think it's wrong. Because I think in contrast to Frankfurter, Scalia is not afraid to develop a kind of compressed, exportable, articulate theory. This is very much along Larry Lessig's lines. And that theory allows others to criticize him when he falls short of his own principles. But there's an upside as well. Many justices who are afraid of criticism develop no articulate theory at all, and they end up never saying much that's memorable or influential. So the irony is that people who act fearfully with a view to preserving their reputation and legacy, they end up losing even those things too. So they don't get the reputation or legacy that they were anxious to protect. The normative ideas for those who vehemently disagree with the justice's views on a range of issues. Let's just stipulate that you're right and Justice Scalia is wrong. I hope you can nonetheless admire the courage with which he fought on in a losing cause. Maybe not. Maybe you subscribe to some version of what philosophers call the unity of the virtues, according to which all virtues must co-occur. And maybe you think that if the justice was wickedly wrong about your favorite cause, then he must have nothing else to recommend him. But I don't think we should think that way. Many of us admire the steadfast courage of, I'm just going to pick an example, Eugene Debs, even though I think his cause was wrong-headed and harmful. And I suggest you should see Justice Scalia in exactly the same light. Thank you.
Thanks very much, Adrian. I think we'll go next to John Manning.
So in the days and weeks to come, much will be said about Justice Scalia's legacy. People will debate the pros and cons of his decisions and how he expressed himself. And that's something he'd very much have welcomed because there's nothing he liked more than to make people think. Today, however, I want to tell you about the man I knew who was my friend and teacher. I clerked for Justice Scalia almost 30 years ago when he was a young man and a fairly new justice. He'd been on the court only 2 years. And he'd spent his life teaching administrative law and not thinking that much about criminal procedure or constitutional law. And he knew that he still had a lot to figure out. What struck me immediately about my new boss was that for him it was all about the ideas, about mixing it up, about arguing so that you'd come out closer to the truth. Sometimes he'd have to remind us, hey, it's my name that's going on the opinion. And sometimes that would be followed by, and I'm not a nut. But that just underscores how free he made us feel to express ourselves and to disagree with him. So here's how it worked. Each clerk would meet with him individually to talk about the cases assigned to that clerk. And I'll say the first time that I met with him about a case, we both started by saying, easy case. And then we simultaneously said, affirm and reverse. He was right. On the days before the court met to decide cases, his 5 law clerks, my term 3 conservatives and 2 liberals, would meet in his office with him the day before. The person responsible for the case would present the facts and the question, and then all 6 of us would argue about it. My recollection is that the discussion was often heated, but only in a good way. We debated the issues thoroughly and fiercely, and it was rare indeed that the lines of division among the clerks broke down on political lines. We felt free to say whatever we thought would help get to the right answer. We felt free to disagree sharply with Justice Scalia, and he with us. I will say that usually the strongest he would say to us would be to smile and wave his hand and say, get out of here, that can't be right, right? You remember when he... And the only time he really pulled rank, as I mentioned, was when he would make his final decision, which, of course, Article 3 entitled him to do. Justice Scalia was also a natural teacher. He would always tell us that part of what we were entitled to as law clerks was to understand the court. And so after every conference, he would call all 5 of us into his office and ask us each to predict, case by case and justice by justice, how the case had been decided by the court. It was unspeakably fun, and he was always playful about it. And he'd rewrite our drafts from top to bottom. Well, at least he would rewrite mine from top to bottom. And he would always tell us why, and it would help us learn. We all tried all year to get a Scalia-like line into one of the opinions, but no one could write like Justice Scalia. The Justice Scalia I knew was also fun and funny, albeit, I'll have to admit, in a nerdy kind of way. He'd walk into our office muttering something in Latin, like, premonitus, premunitus. And we'd say to the justice, we have no clue what you're saying. And he'd feign shock and disappointment You mean you don't know praemonitus, praemunitus? You've got to know that one. And then he'd gently walk us through the Latin roots of those words so that we would understand, even 30 years later, as it turns out, what they meant and why. Justice Scalia was a wonderful boss, and for 30 years, a dear and supportive friend. He was also very good to the Harvard Law School. He visited often and gave generously of his time. He loved his alma mater, and he loved its students, their intelligence, their ambition, the back and forth, the disagreement, and the challenging exchanges that you gave him when he visited. One of the things I often think about in life was an embroidery that he displayed prominently on a table in his office. It was a great lesson for a young lawyer. It said simply, "Nothing is easy." It is not easy to say goodbye to our friend Justice Scalia.
Thanks, John. Cass Sunstein, you're next.
Okay, here are 4 things that I greatly admire about Justice Scalia. First, he's the greatest administrative law justice in the history of the Supreme Court. And for those who love administrative law, that's the highest praise you could pay to a human being of any kind. In cases that involve the EPA and cost-benefit analysis, the authority of agencies to interpret statutes, the meaning of the Clean Water Act, he produced enduring and fantastic opinions. He has a clear sense. It's terrible to use the past tense, so let's not. He has a clear sense of the systemic effects of judicial opinions, of the distinctive competences of administrative agencies, and also of the consequences of legal rulings for what Congress is going to do. So number 1 on the list of administrative law justices. With Holmes and Jackson, I believe he's one of the 3 best writers the court has ever had. Not only because of the clarity and vividness of the expression, but because of a kind of mischief and happy energy. Ebullient rather than bitter characterizes his opinions. And I think, notwithstanding the frequently pointed nature of his dissents in particular, and sometimes majority opinions in response, there's a kind of respect in that he shows to people who have intense disagreements. The third thing I'm going to say that I greatly admire about him is his academic writing as a justice is extraordinarily good and both casts light on his judicial work and has a productive interaction with it. It's a beautiful short essay called Originalism, the Lesser Evil, which gives, I think, probably the strongest argument in a few pages for originalism. His fantastic Tanner lecture at Harvard, The Rule of Law as a Law of Rules, repays careful rereading, and it vindicates rule-bound judicial judgment with greater clarity than anyone had done at least until that time. He has the best argument on behalf of Chevron imperialism, let's call it, in the Duke Law Journal, and he has a fantastic short essay on standing as an essential element in the separation of powers, which makes it much easier to understand what the court's been doing in the area of standing for the last 25 years. The 4th thing I admire about him is what I admire most about him, which is that Justice Scalia was an extraordinarily generous and good person. Not just did he have mischief and humor, but he had genuine warmth. I'll tell you 2 very quick stories. When I was a young law professor, I had a debate at the University of Chicago with him on the issue of standing. And I felt a little bit like I think Bruce Springsteen feels about Cars. That is, standing, that's kind of my business. I know that stuff. And Justice Scalia felt the same way. And we had a very heated, pleasant, but very heated debate. And at one point, I felt I was kind of doing pretty well. And he burst out loudly, "It's common sense." I thought at that point I had won. And I'm completely confident that he thought he had won. And it kind of captured his pleasure in argument and his sense that in the end, really sense kind of matters. At Justice Breyer's swearing in, he came up to me after the ceremony at the White House, put his arm around with me, looked me in the eye, and said, "Cass, first Ruth and now Steve, it's almost enough to make me vote Democrat." And what was so characteristic about that was the kind of human connection and warmth and the bold, italicized almost. And I want to say two things that are kind of questions in the spirit of Justice Scalia's own love of argument. I think that he was not at his very best when his convictions were most intensely felt. That some of his technical opinions are kind of transcendently good, where his convictions were kind of red in color, not communist, but deeply felt. The large abstractions, I think, made his opinions less enduring than they would otherwise have been. That's one question. The other question has to do with the existence of originalist blind spots. So there are areas, and to isolate three, standing, affirmative action, and takings are three, where the historical record is not clearly supportive of his ultimate judgments. And I think it's fair, in his spirit of welcoming contestation, to wonder whether the positions he has defended in those three areas are compelled by or consistent with the original understanding. Still, Justice Scalia was not just a very significant justice. He was also a superb one. You're blessed to be working on law in a time when Justice Scalia has been on the scene. It's a little like people being around at the time, I think, of Holmes and Jackson and Brandeis and the other very few greats. Not just a significant and quite superb justice, but even more important, a deeply good human being.
Thank you. Charles, you're next.
I knew Antonin Scalia since 1985. I was a younger lawyer in the Justice Department, and he was still a Court of Appeals judge. And whether it was meeting him at a Federalist Society jamboree for really young lawyers over pizza and beer, or at the poker table, or arguing to him on the Supreme Court, or watching him as others argued to him, one came away with a sense of energy. This is life. One is enlivened by his presence. And now he's gone. Well, he's not, because of his writing, which we will encounter and generations to come will encounter. And so I thought I would just give you a little bit of that voice and contrast it. And it's very interesting, number of people have already said, he is in that great trilogy of Holmes, Jackson, and Scalia. But there's a difference. Let me give you what very characteristically Holmes said in Buck v. Bell. Very memorable. 3 generations of imbeciles is enough. It is not an argument. It is not the conclusion of an argument. It is just what he said. There's nothing more there, but it's memorable. In McAuliffe against New Bedford, a policeman who had been fired for engaging in political activity, the petitioner may have a constitutional right to talk politics, but he has no constitutional right to be a policeman. That isn't the conclusion of the argument. That's the whole argument. Well, compare that to Jackson, who is really very close to Scalia, both in my estimation and in his intellect. Here is Jackson in the steel seizure case. I am quite unimpressed with the argument that we should affirm possession of emergency powers without statute. And here's the line: such power either has no beginning or it has no end. That is not the whole argument. It is the summation of an intricate, careful argument, which every law student knows, which goes on for pages. But the maxim sums it up. And that is the case with Scalia. There are these memorable maxims, but they either introduce or sum up a careful, intricate, and memorable original argument. Here you are in the independent counsel case, Morrison v. Olson. That is what in this case, the maxim comes by way of introduction. That is what this suit is about: power. The allocation of power among Congress, the President, and the courts in such fashion as to preserve the equilibrium the Constitution sought to establish. Frequently, an issue of this sort will come before the court clad, so to speak, in sheep's clothing. But this wolf comes as a wolf. And there follows an original and remarkable piece of analysis. It's not just the maxim. And one more example. In Mistretta, the Sentencing Commission case, this is an undemocratic precedent that we set, not because of the scope of the delegated power, but because its recipient is not one of the three branches of government. The only governmental power the Commission possesses is the power to make law, and it is not the Congress. I think the court errs because it fails to recognize that this case is about the creation of a new branch altogether, a sort of junior varsity Congress. Well, that's wonderful, except there was an original and intricate argument that preceded it. We will not forget him. He is with us.
Thank you, Charles. Dean Minow.
Just call me Nino. That's the first exchange that I had with Justice Scalia. I was a dean. I've met a lot of famous people. That's not usually how the conversation begins. His warmth and his willingness to just be genuine was what overwhelmed me. And in each of the interactions that I've had with him, that was the overriding experience. His interest in having a genuine conversation, connecting about family, about religion, about law, about ideas, thorough, complete, generous, and engaging. At the same time, he knew I didn't agree with almost anything that he actually concluded, whether it was his methods of interpretation or where he came out in many cases. It didn't matter to him. In fact, I think it made it a plus. He really liked argument and liked discussion and made the teaching, learning, exchange process fun. There's just no other way to describe it. I also, of course, have taught his opinions for years and years. And his sentences, I love the ones that Charles Fried has just quoted, are pithy, memorable, and he has upped the game for the Supreme Court. It's now a competition, I understand, among the justices. Who can write a memorable sentence? It didn't used to be the case. And the same is true with his style of questioning. It's a little bit of a crazy competition, but it has made the Supreme Court arguments real and genuine and meaningful. One sentence that I remember teaching for many years arose in a case involving a claim by a man that he wanted to have visitation rights with a child born to a woman with whom he had had a relationship, but the woman was married to someone else. And Justice Scalia said, California, like nature, knows no family with two fathers. And I've always quoted that sentence, and I'll never forget it, but I always would follow it in class by saying, but he's wrong. This family had two fathers, and go from there. So argument, yes, pithy, memorable phrase for sure, but absolutely it's not the end of the discussion, and it never was with him. In an interview with a law professor in Brazil, before a group of students and colleagues in Brazil, he said something that I think will go to his legacy, and that will be my second to last comment. His legacy will be transformative. It is transformative in several ways. One is by making originalism and textualism meaningful and in many ways dominant challenges and frameworks for analysis. Here's what he said in the interview. He said, I will tell you the killer argument in favor of originalism. I go to law schools just to make trouble. I give lectures and stir up the students. It takes several weeks for their professors to put them back on track. And what I tell them is, ask your professor. Your professor is probably not an originalist. That means you are not an originalist. But that is not a philosophy of interpretation. It just means you do not agree with Scalia. What is your philosophy of interpretation? Scalia knows what he's looking for. He's looking for the understanding that the people had of the terms that were adopted. Once you show him what that understanding was, you got him. He is handcuffed. He cannot do the nasty conservative things he would like to do to the society. This is him. This is him. How do you control your judges? You know what? Think about it. There is no other possible criterion except what did this text mean? What did the people understand it to mean when it was adopted? You either adopt that or you tell your judges, wise, wonderful judges who went to Harvard, Stanford, and maybe even Yale Law School, you must know the answers to all these profound moral questions like homosexuality, abortion, suicide. You either use originalism or you tell your judges, you govern us. Whatever you think is good, it's okay. Whatever you think is bad is bad. This is the challenge that he has created for all of us who do not identify as originalists or textualists. That is a legacy. It will last for decades and decades and decades. But I think as we, in the weeks and months ahead, years ahead, talk about his legacy, there will be many dimensions that will surprise many of us. His upstanding approach to liberty, even in cases that didn't seem to match what his own politics were. I'm thinking of Guantanamo. I'm thinking of flag burning. And in addition, his transformation of the telecommunications industry. He's one of the people who actually sought and successfully achieved deregulation. But the last one that I want to comment on is his demonstration of the possibilities of friendship, not despite, but because of differences. And that is something that this school stands for. I think it's one reason he loved this school. It's one reason I love this school. And here again, I want to end just by quoting him. He said, "My best friend on the Supreme Court is Ruth Ginsburg." Opera, the interviewer said. He said, not just opera, lots of things. We spend New Year's Eve together with our families, and we've done it for 25 years. She's a nice person. I like her. She likes me. But we don't agree on the law, and it's all right.
Great. Excuse me. Well, I grew to be friends with Nino Scalia during our 3 years together in law school. We grew closer when we shared office space for a year, just the two of us at the Harvard Law Review. He was a fantastic office mate and companion. He was a good pal with all the brightness and all the endearing person-to-person qualities you've heard about. We talked about everything that came along, and I have to tell you, I had no inkling at the time of disagreements that developed later. Maybe that says more about me than about him. I wasn't thinking about anything much at that time except doing well in my courses and starting a marriage. But maybe Nino was thinking deeper thoughts. Anyway, we grew up and we grew apart and we grew to disagree, and we kept the friendship going to the end. I'm sure that that fact adds a certain kind of color and tinge to the rest of what I want to say. I think my friend Nino was an exceptionally gifted man in many ways, of which I stand sometimes almost in awe. I think he made major contributions to shaping up and upgrading our practices of constitutional legal contention in ways my colleagues have mentioned. I think he was a man of courage and spirit and dedication to do the right thing and the best for his country and his calling, as it was given to him to see the right. I admire him for, as Larry and Adrian have both mentioned, Adrian put it in a statement a week or so ago, sticking his neck out, putting out on the table a method for judging constitutional cases, a judicial philosophy, as we sometimes grandiosely call it, a method for the merits of which and for the consistency of his compliance with which he made himself accountable. All respect and honor for that to Justice Scalia. He's done everything he could to make sure that assessments of his achievement will not float free of answers we give to questions about that judicial philosophy of his, questions which we've mainly not addressed this morning, though there has been some allusion to them. So maybe bridging to discussions still to come, I'm going to mention some of those, honoring, I believe, Justice Scalia's own spirit as I do so. So, what do we think? And what will history say about that judicial philosophy's suitability to the time and the country and the conditions in which it was brought to bear? What do we think about its founding premise? Do we really do best to treat our Constitution as a lock-in for more or less specific political ideas and conceptions accepted by majorities and on their minds at the time of the formation? Would we do better to treat it as an open-ended pointer towards a better future and continued progress towards liberty and justice for all? Is the answer sometimes one and sometimes the other? There are arguments pro and con. Justice Scalia was not enough. There are arguments pro and con. Where do we come down? Should our answers turn at all on what we think of specific results and votes towards which his own premise helped to lead Justice Scalia? And what, in fact, will we say about the breadth and consistency of Justice Scalia's applications of the precept of interpretation by original public meaning? Cass Sunstein has mentioned important instances where the justice or the judgments he joined actually were not and could not have been founded on a proposition about original public meaning. They could only have been guided by a broadly constructive approach that aimed to make the best overall sense of the Constitution and principles to be drawn from it, which of course would have to mean best in the eye of the constructor? We haven't gotten much into such questions today, but I guess they and others must be on the minds of many of us here. There are a couple of minutes left, so I'm now going to tell a story of my own, which will harken back more to the beginnings of my remarks, though the story doesn't come out of our law school days together. It comes from many years later. I think the year must have been 1990. Sometime around 1990, there was an event at the Supreme Court, and I'm thinking that event must have been somehow or other in connection with the retirement from the court of Justice Brennan, for whom I clerked. So it would have been in or about 1990, and that fits with other factors of our relative age and so forth that are involved with this. I was there. People were kind of milling around one of the big conference rooms, the big ceremonial rooms at the Supreme Court before the scheduled events were to begin. And my old friend Nino walked in, and of course we began to engage ourselves in conversation about our families and our lives. And at a certain point, he kind of fixed me with a look and jabbed a finger at me. He said, "Michaelman, how many grandchildren do you have?" Uh-oh. Uh-oh, I'm thinking. Most of you probably know that Nino and Maureen Scalia are the parents of 9 children. Well, I'm sort of a little bit embarrassed. I draw myself together. I do a rough calculation. And I say to him, "Well, Nino, we have 1. We were at that time 50, 55, 56 years old. I got 1. How many have you got?" I think, well, I have to ask this. I mean, it's expected, right? So in fear and trembling, I said to him, "Well, Nino, how many do you have?" He said, 4. I feel myself breathing a little bit of a sigh. Really? Well, 4, 1. I mean, it's not quite, not orders of magnitude. So before I could stop the words from coming out of my mouth, I said, "Oh, that's not so many." And quick as anything, the grin beginning to take over his face, he said, "Well, yes, but wait until we get into full production." So that probably conveys a little bit of a sense of the charm of the man. And in many ways, I think we can say, listening to the remarks around the table and reading around and listening around as we have been this past week, I think we can say Justice Scalia's offspring are legion. The actual number, the actual number is 28 or 29.
36.
Oh, it's up to 36 now. So you see, it's growing since the last time I checked. So that's it, everybody. Thanks very much for coming. We've enjoyed this, and I hope you